my paper starts with the question that I ask my company law students at the start of every year. What do the Deepwater Horizon tragedy, the global financial crash, and British colonial oppression in India have in common? The answer is they were all undertaken by companies, or all caused by companies at least. Yet traditionally, company law tends to minimize the role for company law in resolving any of these issues. So, to avoid a future Deepwater Horizon, we look to environmental law. To avoid a future financial crash, we look to financial regulation. To stop the Brits being nefarious overseas, we have an array of domestic legislation which falls outside company law to deal with things like the Bribery Act, modern slavery, etc., etc. With the result being that overall, as Pierre-Henri outlined yesterday, these issues have nothing to do with company law. But I want to respectfully argue against that position. I want to argue that it is a problem for company law because company law creates the problem. The incentives in the company form create the problem, and therefore it's for company law to resolve it. And if we leave it to other disciplines to resolve the issue, then they might miss the nuances of corporate law. We had that in Scotland recently with issues over Scottish limited partnerships, where criminologists misunderstood the nature of the vehicle and therefore proposed solutions that were disproportionate to the issues. So if we leave it to non-corporate specialists to resolve issues that corporate law creates, we risk them getting it wrong, and it's abrogating our responsibility as corporate lawyers. So ultimately, this then is an argument about incentives. And there's a wonderful quote on that slide from William Mettling and Armand Alchian from 1960 that says, "Through the ages of Tutankhamun, Alexander, Caesar, Louis XIV, and the atom, incentives have remained the same. Humans want, and have always wanted, exorbitant wealth, tyrannical power, idolatrous prestige, lavish consumption, and undisciplined leisure." And the argument in that paper is they do achieve those in two ways. Firstly, we use the existing rules of the game to our advantage wherever we can. And secondly, we change the rules of the game whenever we can, once more, to achieve these goals. Yes. And perhaps only even some men as well, not meaning to tar everybody by this brush. But this focus on operating the rules of the game and changing the rules has evident application within company law. And in particular, the incentives aspect of company law has been alleged on a number of occasions. The argument tends to be that company law incentivizes shareholders to push companies to undertake riskier activity than the equilibrium. Whatever the equilibrium may be, the features of company law push shareholders to adopt a more risk-seeking profile than that equilibrium would be. Why is that? Because they get the payoffs of such riskier activity working off without losing if it doesn't, there's no downside. And variations on this theme have appeared since Hansman and Crackman in 1991 on unlimited liability for shareholder liability for torts, and Goodhart and Lastra a couple of years ago in the Journal of Financial Regulation. Limited liability gets the blame for this in most occasions. But I argue in this paper that actually this incentive doesn't just come from limited liability. Easterbrook and Fischel proved that we all have limited liability all the time. It's ubiquitous, it's the norm. In this room, each of us have limited liability for each other's actions. For every setting other than a general partnership, everybody has limited liability everywhere. So it can't just be limited liability that causes this incentive. Instead, it's limited liability coupled with some other corporate law features. The variable uplift that shareholders can receive, the residual claim, the fact that their claim isn't fixed but goes up the better the company does. Couple that with major control over major decision making, the ability to push the company to do things, and limited liability. Those three things together create this incentive. And it's easy to see how you need those three. If you take any one out of them, the incentive falls away. If you take out a variable uplift, there's no need to push for riskier business. If you take out a voting right or a control right, there's no ability to do anything about this incentive. And if you take out limited liability, the incentive is mitigated because any gain from the abuse of the corporate form will be clawed back in the longer term, thus reducing the incentive in the first place. So you need all three of these things together, which company law does provide in order to create an incentive. And each of these three are agreements between the shareholder and the company. Company law provides for these agreements. So it's an agreement between A and B. And that's relevant when we try to work out what this incentive is in economics terms, because sometimes it's called a moral hazard, sometimes it's called an agency cost, sometimes it's just strategy. Now, I don't have time to go into the delineation between the three of them, but I argue that it must be an externality, a classic Pigouvian externality, because it's an agreement between A and B that harms C, the classic definition of an externality. Now, once you start getting into externalities, the literature is complex and voluminous. There's been a recent review in 2019. But the basic concept is that the actions of two individuals can harm a third, and that's Skytowski from 1954. And in this case, I argue that the agreement between the shareholder and the company to provide these features to the shareholder facilitated by company law causes damage to third parties. Now, I mentioned there's complications when you get into externalities, and that's because of Coase. Coase really muddied the water by arguing that there's a reciprocal element to externalities, that the sufferer causes or contributes to the harm as well. Now, William Baumol had a brilliant response to that to say, if that's the case, then the murder victim should also be an accomplice in their own, the trial of their attacker. But I don't think that really matters for lawyers, because the economists can debate the extent to which externalities exist, but lawyers and law concentrates on what you can and can't do, permissive sets of behavior, especially the harms that you can and can't cause to third parties. So my argument then is that corporate law features create this incentive for externality, and if the corporate law creates it, it's clearly the role of corporate law to resolve it through company law, through state action. And why does this matter for the theme of the conference? Externalities are the major problem in sustainability. Quotes abound on this, but the one there on the slide, without externalities, the problem of sustainability vanishes. So we create through corporate law an incentive for externality, and that harms sustainability. So we need to do something about it. So what can we do about it? Well, if it's created by these three features, we need to play around with these three features in order to mitigate it. Now, the harm that's caused by this incentive for externality is relatively constant. It's relatively fixed. So why do we provide these features to shareholders? Well, the benefits of providing these features vary. Harms are fixed, benefits vary, especially arguments in favor of limited liability. And most arguments in favor of limited liability are predicated upon shares being listed on a capital market. If you remove the capital market, most of the published arguments in favor of limited liability go away. So what arguments do we have in favor of limited liability? Well, I mentioned the Easterbrook and Fischel argument that everyone else has it, and that remains the same. There's a tacit argument floating around that somehow limited liability and company law benefits society through trade, that it somehow generates positive externalities. But this is often unquantified and rarely directly argued. Instead, what's mostly argued is a series of private benefits given by limited liability. So Henry Manny told us that limited liability fixes shareholder risk, and that enables diversification. Once you take a capital market out, that's not so relevant. Shareholders aren't as likely to want to diversify when we're talking about private vehicles. Susan Woodward said limited liability lowers the cost of monitoring management. Well, if you're more involved in the company, as private shareholders are likely to be, you're less likely to have a monitoring need in the first place, because you're going to be more involved. So that benefit as well goes away when we take out the capital market. Similarly, there's arguments on monitoring of fellow shareholders. You don't need to spend as much time monitoring fellow shareholders if you have limited liability. Once more, in private vehicles, shareholders are more likely to be involved in a number of capacities and therefore less likely to need to monitor in the first place. So again, that benefit is much, much lower when you remove the capital market. The Gilson and Crackman argument is that limited liability makes shares fungible and entirely linked to the performance of the company. Once more, that's not the case in private companies anyway, and so that benefit goes away. It's been argued that limited liability helps rich investors get comfortable investing alongside less rich investors. Once more, when we talk about private companies, the identity of the people you're in business with is likely to be more important, and therefore that benefit falls away as well. Grundfest argues that limited liability is required for a capital market. When you take away the capital market, that argument goes away. And Booth mentioned that this capital market then facilitated through limited liability can discipline directors. Once again, that argument falls away when we have we take away a capital market. So this means that my argument is we should have limited liability where we have shares listed on a capital market as all those benefits stand. But the benefits fall away when we take away a capital market, and therefore we should possibly, to mitigate this externality, not have limited liability for companies whose shares aren't listed on a capital market. That includes private companies and subsidiary companies in a group setting. And what does that mean for the UK corporate landscape? Well, I had some empirical research undertaken. As at June 2021, there are about 5 million vehicles on the UK corporate register. Most were very small. We only had about 6,000 public companies. That's 0.12% of the UK corporate register. About 1,400 had their shares listed on the London Stock Exchange. And when you pluck out the alternative investment market and investment companies, you're left with less than 500 companies listed on the main market of the London Stock Exchange, which are UK trading companies. So, removing limited liability will remove the incentives for corporate externality for the vast majority of companies. And this means that we should retain it in certain cases, but it would be a very limited position of a much smaller number of companies. And it should be noted that prior to the statutory introduction of limited liability in the UK, courts were very reticent to uphold limited liability on third parties. It's been often referred to as a privilege in numerous capacities. And I think that lets us categorize limited liability where it would remain under this model, which has limited practical chance of ever taking off, of course. Just think of it as a thought experiment. But in those cases where it remained, we could think of it as a gift from the state to those remaining companies. And that argumentation structure really takes us back into yesterday's discussion of concession theory and the legal personality debates that Susan outlined in 2019. So if limited liability in the situation in which it should remain, being on low shares listed on a capital market, in those circumstances, it would be a gift from the state. And seeing it as a concession approach, a gift from the state, lets you explore counter concessions, lets you set limits to those concessions and explore counter concessions. And this sounds very radical, but actually we already do this already for companies. Limited liability comes with a series of limitations on its concession and counter concessions. In the UK, a limited company has to include the word limited in its name, a counter concession in exchange for the gift of limited liability. We have capital maintenance rules that are rigidly enforced and transactions are recharacterized as falling within them. We have minimum capital requirements, which are quite laughable, but nevertheless technically there. And we double tax companies. We tax companies on their profits and then shareholders on their profits as well. Again, another counter concession that the state gets. So what can we do for the remaining companies in order to remove corporate law's incentive where limited liability should remain? Well, there we have a couple of options. We can play around with either of the two remaining features. We can limit the variable uplift, and there's numerous models in which we can do that, or we can limit major decision-making power for shareholders. So, in conclusion, limited liability itself isn't the problem, but it is a key part of the corporate incentive, alongside a variable upside and voting rights. This incentive manifests as an externality caused by corporate law's three features. Corporate law causes this incentive, so corporate law should remedy it. So limited liability is, my proposal is that it shouldn't be the default, it should only be there for public companies listed on the capital market, and this will resolve this externality for the majority of things. For public companies, we should recharacterize the remaining limited liability as a state gift, which can be resolved, in which case we can resolve the incentive by limiting the variable upside or limiting voting rights. Thank you very much for your time.